what it is you can expect to see in terms of the new lease, in that the Act specifically deals with things like the property that will be demised under the lease. And you might think that's just the property, but as we'll see, it can be a little different. The length of the new lease, the rent under the new lease, and then the sort of all-encapsulating Section 35, the other terms under the new lease. So the new lease is not identical to the old lease, even though we tend to think same terms and conditions. Now, the old lease is not, the terms of that are not set in stone, but it's hard to get a change. And so we'll look at some of the areas where the courts have actually opined on whether or not changes will be allowed. And they will finish off by looking at other recent news, including a couple of cases. And as I say, the proposals for reform. So rent. This is an area that is not for lawyers, obviously, because we're not valuers. And so you're going to need a valuer involved here. But it is important to look at some parts of this. And it's very easy for us as lawyers to say, that's a valuer's job. I'm not going to deal with this at all, and not even read the evidence. And if you are advising your client, and in particular, if you're going to bring this matter before court, if you haven't read and dissected the evidence, you haven't done your duty by your client, because the evidence you're bringing forward may or may not be strong enough to persuade the court. And it may mean that the evidence you're looking at is actually going to impact how the client should actually take this matter forward. So it's really important to take this evidence very seriously, even if you're not going to go to court. So the rent is that which, having regard to the terms of the tenancy, might reasonably be expected in the open market. And there are some mandatory disregards, as you can see. You disregard the tenant's occupation and you disregard the goodwill of the tenant's business. And that's going to be important when we come to look at turnover rents. You also disregard certain improvements and any tenant's license. So those are things that the surveyor is going to have to take into account. So there are a couple of rules that the Court of Appeal has laid down. First, that so far as reasonable, leases don't prevent the landlord from using the premises for development. So that would play into the length of the lease, but it would also play into the insertion of a landlord's break clause. And secondly, that a reasonable degree of security of tenure should be provided for the tenant. So again, if you want a landlord's break-in, that might comply with the first part of this rule, or first rule, but maybe falls foul of the second rule. And as Lord Justice Fox acknowledged, those considerations are obviously to some degree in conflict.